Supreme Court allows Trump to fire F.T.C. Commissioner. This article is by Abby Vansickle and Anne E. Marimo and read by an automated voice.
For you?
The Supreme Court on Monday allowed President Trump to fire a leader of the Federal Trade Commission, setting up a court battle over a 90-year-old limit on executive power over independent agencies. In an emergency order, a divided court announced that it would allow President Trump to fire Rebecca Kelly Slaughter, a F.T.C. commissioner, and that it would hear argument in the case in December, a signal that a majority of the court is ready to revisit a landmark precedent limiting presidential authority. Mr. Trump had fired Ms. Slaughter and Alvaro Bedoya, two Democratic members of the F.T.C., in March. The federal agency, which enforces consumer protection and antitrust laws, typically has 5 commissioners, 3 from the president's party and 2 from the opposing party. After their firing, the 2 commissioners had said they planned to challenge their removal in court, relying on a 1935 landmark Supreme Court case, Humphrey's Executor versus United States, that also involved the firing of an F.T.C. commissioner. In its brief order Monday, the court said it would consider in December the broader question of whether to overturn the precedent that has prevented presidents from removing independent regulators without cause and solely over policy disagreements. The decision by the court's conservative majority to allow Mr. Trump to remove Ms. Slaughter drew a dissent from the 3 liberal justices. Justice Elena Kagan said her conservative colleagues had essentially allowed the president to take charge of agencies Congress intended to protect from partisanship. She wrote that the court's majority, order by order, has handed full control of all those agencies to the president. The justice continued, "He may now remove, so says the majority, though Congress said differently, any member he wishes, for any reason or no reason at all. And he may thereby extinguish the agency's bipartisanship and independence." Justice Kagan pointed out that in the 1935 case, the Supreme Court had rejected a claim of presidential prerogative identical to the one made in this case. She added that although a majority of justices may be raring to overturn that precedent, for now, it remains in effect. She also laid out a broader criticism of the court's emergency action in this case and others, writing that the court's emergency docket should never be used, as it has been this year, to permit what our own precedent bars. She added that it should not be used, as it also has been, to transfer government authority from Congress to the president, and thus to reshape the nation's separation of powers. Unlike merits cases, which receive full briefing and often months of consideration, emergency applications are often decided on a truncated schedule without oral argument. Justice Kagan was joined by Justices Sonia Sotomayor and Ketanji Brown Jackson. In a series of cases, the Supreme Court has signaled a willingness to potentially overrule the precedent and at some point declare that laws shielding agency heads from presidential ouster are unconstitutional. Still, the justices have not yet formally done so. The justices are separately considering the Trump administration's request to remove Lisa Cook as a Federal Reserve governor. The Supreme Court has yet to act, but has suggested that the central bank may be insulated from presidential meddling under the law. Both commissioners in the F.T.C. matter contested their firings, but Mr. Bedoya ultimately resigned in June, saying that he could not continue without income as the case proceeded through the courts. Ms. Slaughter pushed ahead with a lawsuit challenging her firing, arguing that she was terminated without reason and should be allowed to resume her role at the agency. In July, a U.S. District Court judge ruled for Ms. Slaughter, finding that her firing by Mr. Trump was illegal and that she was a rightful member of the agency. The judge, Lauren L. Ali Khan of the U.S. District Court for the District of Columbia, cited the long-standing Supreme Court precedent, finding that because those protections remain constitutional, as they have for almost a century, Ms. Slaughter's purported removal was unlawful and without legal effect. The Trump administration then filed for a stay of that decision with the appeals court. In early September, a divided appeals court panel reinstated Ms. Slaughter. In their ruling, judges from the U.S. Court of Appeals for the District of Columbia wrote that the president had fired the commissioner without cause. A commissioner cannot be fired without the required grounds of inefficiency, neglect of duty, or malfeasance in office, they wrote. Shortly after, the Trump administration asked the Supreme Court to weigh in and allow the president to fire Ms. Slaughter. In court filings, Solicitor General D. John Sauer argued that the justices should find that the president had the authority to fire Ms. Slaughter, claiming that lower courts had applied an overly expansive view of Supreme Court precedent. Mr. Sauer maintained that the F.T.C. had changed in recent decades, amassing considerable executive power in the intervening 90 years. Mr. Sauer argued that the F.T.C. case was indistinguishable from other firings of federal agency leaders that the justices have allowed to go forward, including the court's decision in late July to allow the firing of 3 Democratic members of the Consumer Product Safety Commission, a 5-member group that monitors the safety of items like toys, cribs, and electronics. On September 8th, Chief Justice John G. Roberts Jr. issued an order temporarily allowing Mr. Trump's firing of Ms. Slaughter, while the court considered the administration's emergency application. In response to the Trump administration's court filings, lawyers for Ms. Slaughter again pointed to Supreme Court precedent, arguing that her firing was illegal. 90 years ago, this court was tasked with deciding whether the president may fire a commissioner of the Federal Trade Commission without cause, they wrote in a brief to the justices. The court ruled that he may not. A decision to allow the president to fire Ms. Slaughter, her lawyers argued, would mean the agency Congress created would be severely wounded and radically transformed.